Good morning, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Lobe TV. If you haven't already, please, if you don't mind, go ahead and hit that subscription button, turn that notification bell on, and hit that like button. I'll give y'all a second to do that. Okay, y'all. So what I'm going to be commenting on today is administrative hearings. This scene right here, what I'm going to show you is from a season of Better Call Saul that I watch from time to time. This will be on season 3. I think it's episode 5, and the name of the episode is called Chicanery. So, what I'm gonna be doing is I'm gonna pause the video from time to time and provide y'all with some commentary on what I think based off of the case law that I have read in the past in regards to administrative hearings and so on and so forth like that. And then I'm gonna be showing y'all some case law, a little case law here now. So this video is probably gonna be close to probably about an hour. So y'all just bear with me. All right, y'all. This is the video that I tried to upload probably about 2 weeks ago, maybe, but I couldn't get the video on because there were some copyright issues, and it's due to this scene right here. So I gotta figure out what I'm gonna do. I guess I'll try to explain it. Let me see if I could go forward in here. I can't do that. Okay. All right. So right here, in this episode, this guy right here, James McGill, he is being so-called charged by the state bar for ethical code violations of that state bar because he's an attorney there. Now I want y'all to pay attention, okay, to what I'm about to say. That ethical code that they are so-called charging him with is not law. It is a form of law, and it has the force and effect of law, but it is not law unless you voluntarily make yourself subject to it by probably, I would say maybe some sort of minimum contact or something like that, or some sort of contract, something like that, which is essentially what he did. He signed up for this, you know. But again, that code is not law, and it does not apply to anybody else who is not a member of that bar. It's just like in Alabama, they have judicial canons, and these judicial canons are not law because they don't apply to everybody. They just apply to members of the judiciary who voluntarily make themselves subject to those canons, if that makes sense. That is the same exact thing with statutes. Statutes are a form of law. It is not law. They are not law. They do have the force and effect of law. All right. Now, this hearing, what you're going to see, is probably not going to let me play you too much of it because there are some copyright issues, which sucks because they actually have a trial in here at this bar. So let me see if I can skip through it a little bit more. Give me a second. Like when you hold on. All right, I'm gonna stop the video right here. Hopefully this is good right here. Y'all just bear with me. I'm sorry. Bear with me. It's always substance over form. Damn it. All right. Here we go. So y'all paying attention. Y'all see this? Y'all to pay attention. There's not a jury in here. This is an administrative hearing. Okay? Pay attention, y'all. And these three up here, These are executive officers, and they are enforcing codes. They are enforcing their codes, just like they do to your ass when you go to court. When they charge you with a violation of a statute that is comprised within their state code or something like that, that's exactly what this is, y'all.
Turn over the evidence he'd been
collecting. Objection. We have.
See that? She just made an objection. This is a trial, y'all. This is an administrative trial. It looks just like a court, don't it, y'all? Doesn't matter. I don't care because it looks like a court. It's not a damn court. It's an administrative agency. It's no different than the Department of Motor Vehicles, the DOJ, the ATF, CIA, the Department of Transportation, Child Protective Services. It's an administrative agency. That's exactly what this is. You can have an administrative hearing at your house. It doesn't have to look like one for it to be one. Let's say if you're in jail and you get charged with promoting contraband or something like that. So that's some sort of code violation within that administrative agency, because a prison is an administrative agency. They are enforcing statutes and they're following statutory procedures. So you get charged with a code violation in that prison. You are going to get an administrative hearing from officers of that prison, and you are a damn fool if you think that that administrative hearing is going to be fair. I want to play y'all some more of this, but I can't because it's copyright issues. I really do want to play y'all some more of this stuff. So I'm gonna end this right here, and I'm gonna go back to some stuff because I want to show y'all what's good. Well, let me talk a little bit more. I'm sorry. This administrative agency is exercising plenary power, meaning that they are exercising legislative, judicial, and executive functions. These are all executive officers, and they're acting also as judicial officers to enforce their codes.
Haven't established the tape is evidence.
All right, I'm gonna stop that right there. Y'all just keep that thought. This is an administrative agency, and they're exercising plenary power. Y'all hold that thought. All right, now let me go to this right here because I want to talk about this. This is Yusuf L, and this is what Yusuf is he's talking about something like this. He's telling you that you're in a colorable court where they're using colorable law and colorable money. Federal Reserve notes are not money. All right, it's not money. It's a negotiable instrument. The reason why this so-called court is a person, it is a corporation, is because they are using negotiable instruments. That's what they're doing. And they are no different than a private citizen. They have an EIN number and they have a DUNS number. It is a fucking corporation. It is a person. That's what it is. So give me a second.
Money. They're using Federal Reserve notes. How can you? That's why there are no common law courts.
I'm gonna stop right there. Common law courts do exist. They are called courts of general jurisdiction. Courts of general jurisdiction are courts that are created by the Constitution, not statutes. In other words, they are created by the sovereign people within that so-called state. Courts of general jurisdictions hears cases at law, which is common law, in equity, which is a court of chancery or something like that, maritime and admiralty. Courts of general jurisdiction do exist. They also call them superior courts. The legislative so-called courts are called inferior courts. In other words, are administrative courts. I don't call them courts. I call them administrative agencies. That's what I call them because that is what they are. They're administrative agencies. So let me go on a little bit more.
Because the money they charging you with is not constitutional. So how can it be a constitutional court? How are you going to give me a traffic ticket for Federal Reserve?
All right, let's go. I'm going to have to go down a little bit more, y'all, because I don't want no copyright issues with this either. Well, no, I'm gonna let this play. I'm gonna go ahead and let it
Reserve
play.
notes, and in the Constitution, it tells you that debts can only be paid in gold and
Gold and
silver.
silver.
But you're right there in court trying to pretend like this is some court of law, trying
It's
to
not.
pretend like this is Article 3 court.
It's not. It's an Article 1 court. It's a legislative court. That's what it is. And I'm gonna show y'all a case. I've already shown it before, but I'm gonna show y'all again. Once he finishes talking, because I want to let y'all know that this man is not fucking crazy, and you're not crazy either. I'm tell you, what was I gonna say? I remember I was in court, and this was all new to me. So I'm just trying stuff out. I really, to be honest with you, at that particular time, I didn't know what the hell I was doing. I was just trying some stuff out, y'all. So I started asking questions in regards to, the nature of the action. And the question was like, Your Honor, pursuant to the Sixth Amendment of the Federal Constitution for the United States of America, I have a right to know the nature and cause of this action. So can you tell me if this is a civil or criminal action? It's criminal. Okay, thank you. Let the record reflect that the action being brought against the defendant is a criminal action. Now, Your Honor, pursuant to the Federal Constitution, which only permits 2 criminal jurisdictions, can you inform me which of these 2 criminal jurisdictions this case is being prosecuted under? Is it common law or is it admiralty? The question was some along the lines of that right there. And he looks at me. We're in a circuit court, so-called circuit court. He looks at me. There's a court reporter in there too, so that she's taking down everything. He looks at me. He pauses for a second, and then he opens his mouth and he say, "It's not common law." And he shut up. He didn't say nothing else. And that was it. I know it's not equity because there are no statutes in equity. And there's no criminal jurisdiction in equity. And you just told me it's not common law on the record. So what other jurisdiction is it, y'all? It's admiralty. So there's, in my opinion, there's some sort of maritime contract in there being enforced. And if there's a maritime contract in there anywhere, then admiralty jurisdiction attaches. And admiralty jurisdiction, it deals with the sea, yeah, it does. But it's the nature of the contract that determines the nature of the action. That's just like the nature of your pleadings determines the nature of the action. So if you're pleading facts of a equitable nature, then the nature of the proceedings, or in other words, the jurisdiction of the proceedings, would be equity. It's an equity jurisdiction. You're pleading facts in equity, and you're asking for an equitable remedy. So the nature of the action in regards to jurisdiction would be equity. But let's go on.
Or some type of judicial proceeding, when we know this is a territorial court operating outside the Constitution.
They don't have any judicial authority, y'all. They call it quasi-judicial authority. It's as if. I'm going to tell you what power that they're exercising. It is plenary power. Like that administrative agency that I just told y'all about earlier in this video. That is what they are exercising. Is plenary power. And that is in another jurisdiction. In that particular jurisdiction, they are sovereign. That's why they can do it. So, but the problem is you can't really see this territorial jurisdiction. I don't think it's concrete because I haven't really been able to find any cases on it that would substantiate it. Kind of just like public policy, because they don't even know what the hell public policy is. When I say they, I'm talking about the attorneys. But give me a second. I'm gonna let this play a little bit longer, and then I'm gonna go and read y'all the case.
Well, let me qualify that. Within the ambit of their delegated authority, where they have plenary power, according to Article 1, Section 8, Clause 17 of the Constitution. These are Article 1 courts. Article 1.
He's talking about the federal Constitution, just to let y'all know.
Section 8, Clause 9 gives your legislature the authority to institute tribunals that are inferior to the Supreme Court. And they do it on the state levels too.
Yep.
Separation of powers is not just on the federal level, it's on the state levels too.
All right, I'm going to stop right there. Now, I'm going to show y'all this case. I've done it one time. I'm going to do it again. Should be... Is it? No, it's this one right here. All right. This is an Alabama Supreme Court case from 1947. So let's go down. And I'm going to highlight it right here. This case is based on State ex rel versus Winter v. Sawyer. And then there's the case citation, where in dealing with the distribution and exercise of the judicial power, it was said the system is in itself and of itself complete. And though there has been a grant or reservation to the General Assembly, the General Assembly is synonymous with legislature, of power to establish inferior courts of law and equity. I'm calling them administrative agencies. That's what I'm going to call them. There has not been any part or any fraction or fragment of judicial power left in abeyance, awaiting the happening of any future event or the exercise of future legislative power to vitalize or quicken into activity. So what they just said is, even though the Constitution basically permits them to do that, they don't have the judicial authority as courts of constitutional origin. Let me rephrase that. They don't have the judicial power similar or equal to the courts of constitutional origin, is what I'm trying to say. Now, this is the General Assembly. This is the legislature. All right. Now, we have separation of powers. All right. So if we have separation of powers, how can they be exercising judicial power? It's not judicial power. It's plenary power. I'm going to read it over again. There has not been any part or any fragment or, any fraction or fragment of judicial power left in abeyance, awaiting the happening of any future event or the exercise of future legislative power to vitalize or quicken into activity. If the General Assembly never exercised the power to establish inferior courts, legislative courts, statutory courts, with which it was clothed, and its exercise is purely a matter of legislative discretion, the whole element of sovereignty known as judicial power would exist, confined to tribunals which may properly be said to be of constitutional creation. It's plenary power, y'all. That's what they're exercising in these inferior so-called courts. It's plenary power. And plenary power, what did I tell y'all? Plenary power, they're exercising legislative, judicial, and executive functions. That's what they're doing. Just like administrative agencies. Why? Because they are akin to administrative agencies. It's like they first cousins, y'all. I don't care if they call it a court. The legislature can create a court via statute because they're authorized to do that, but it doesn't matter if they call this the Supreme Court of the entire world because of separation of powers. It has to be, by default, an inferior so-called court. So they can create a court called the Supreme Court of the United States of the entire world. It's still an inferior court. And they can deposit judicial power in that so-called court. That's what they like to call it, but it's really plenary power. It's a territorial court. It's really plenary power. That's what they're doing, y'all. That's why administrative agencies exercise all three so-called powers of government: legislative, judicial, and executive. Administrative agencies are a part of the executive branch of government. They are enforcing the law, the so-called law. But pay attention now, because these statutes, codes, I don't care what they call it, they are only a form of law. They are not law. And they do have the force and effect of law, but only on those who voluntarily subject themselves to that particular jurisdiction. And when I say jurisdiction, I'm not talking about a particular place. I'm talking about authority, because that's essentially what jurisdiction is. Y'all got to pay attention, man. It's not a court, man. These are some sort of territorial administrative agencies. That's what I call them. They are administrative agencies. That's what they are. So I'm glad I got this out. I really wish y'all could have saw it, because they actually had a whole trial on this case right here, man. It went on for like 20 or 30 minutes. They had a whole trial in there, man, on that case. Whole trial. So let me go back. I think that'll be it, y'all, because I don't want to make this video too long. So hopefully this helps. I don't think I forgot anything. Anyway, that'll be the end of this video. The Supreme Litigant is out. Peace.